Hi, my name is Elyssa Tenenblatt, and I'm an associate attorney at Holland Law Group. I handle bankruptcy filings in the Middle and Northern Districts of Florida, assisting clients from Manatee County all the way to Escambia County in the Panhandle. At Holland Law Group, we strive to guide our clients through challenging financial issues by providing the best solution for their situations. And sometimes this solution happens to be bankruptcy. Many of our clients find themselves in unavoidable situations of financial struggle. We understand that dealing with financial distress is emotional, stressful, and sometimes scary, and with our firm, you don't have to face it alone. We've all heard the term bankrupt, whether it be everyone's favorite regional manager from Scranton, Pennsylvania, screaming, "I declare bankruptcy!" or contestants attempting to avoid the bankrupt wedge on afternoon television. It's something that many people know by name, but don't know much about. At Holland Law Group, we know how important it is that you have a thorough understanding of the issues you're facing. In this video, I will discuss the different types of bankruptcy and which one may be right for you. But first, let's start with the basics. There are two chapters of bankruptcy that individuals can file, Chapter 7 and Chapter 13. Now I will break each of these down into more detail. The most common type of bankruptcy you will encounter as an individual is Chapter 7. In order to qualify for Chapter 7, your gross income must be under the median income for your household size, or you must pass the means test if you are over the median income. You must also be prepared to surrender all of your non-exempt assets to the bankruptcy court. If your gross income qualifies you for a Chapter 7, then the next step is to determine what your total asset value is. If your gross income is a bit higher than the median income, you could still possibly qualify for a Chapter 7 by doing the means test. The means test is an opportunity to calculate your gross income less your allowable deductions, such as taxes, health insurance, rent or mortgage, and vehicle payment, as well as the IRS allowable living expenses like food, housekeeping, and utilities for your family size. If you qualify for a 7, then we must look at the total assets you have and the exemptions for those assets. Exemptions are essentially the protections you have for certain assets per state or federal law. Florida residents can generally exempt $1,000 of personal property, $1,000 of equity in a vehicle, and their home if they own one in Florida. If they've owned their home for more than 1,215 days, they can protect an unlimited amount of equity. If they have owned their home for less than 1,215 days, they can only protect what the bankruptcy code allows, which as of 2023 is approximately $190,000 of equity. If you do not own a home, or if you own a mobile home and rent the lot, you can exempt an additional $4,000 of personal property. You can also usually keep your current car loan or mortgage if you can afford to keep up the payments. If you can't afford the payments or would like to turn in your vehicle or house, you can choose to surrender those items and not have to pay anything further. Filing a Chapter 7 bankruptcy also gives you the protection of the automatic stay. The automatic stay stops all collection activity and most lawsuits. The automatic stay will also ease most debt-related stress by halting collection phone calls and other creditor harassment, foreclosure, vehicle repossession, and wage garnishment. A Chapter 7 bankruptcy completely discharges your qualifying debts. Most unsecured debts are discharged. Unsecured debts are debts that are not secured by any sort of collateral, as opposed to secured debts, which are secured by property, like a mortgage secured by a house, or a vehicle loan secured by the vehicle. Dischargeable debts include personal loans, credit cards, past vehicle repossession deficiencies, medical bills, and most court final judgments. In some cases, income taxes over 3 years old may also be included in discharge. Debts that are not covered by bankruptcy discharge are most student loans, alimony and child support payments, including the arrears, fines and debts incurred due to involvement in criminal activity, such as criminal restitution, and sales and withholding tax or other government penalties or fines. If you are struggling with unmanageable debt, talk to an experienced attorney at the Holland Law Group about your options. We can advise whether or not you qualify for Chapter 7 and whether this is the most appropriate solution for your particular circumstance. If you do not qualify for Chapter 7, you might be eligible for Chapter 13. Unlike a Chapter 7, which liquidates the non-exempt assets to satisfy your debts, Chapter 13 is the repayment of a percentage of debt over a 3 to 5 year period, after which most unsecured debt is discharged if not paid. Even if someone does qualify for a Chapter 7, a Chapter 13 might be a better option. Chapter 13 might be an option for you if some of your debt doesn't qualify for discharge, or certain assets are better protected under Chapter 13, and you prefer to keep those assets. Unlike in a Chapter 7, your debts are not immediately discharged. A payment plan pays a portion of your debt over 3 to 5 years, and that payment amount is based on your ability to pay, determined by the means test, or the value of your non-exempt assets, whichever's higher. If Chapter 13 interests you, specific qualifications must be met. They are that you have disposable income, that your total debts are less than $2,750,000, including both secured and unsecured debt. You are not a corporation or partnership, and you've not had a bankruptcy dismissed in the last 180 days. Some benefits of Chapter 13 include certain tax debts being paid in full over the plan with no interest charges or penalties, saving your home if you're behind on your mortgage or are currently in active foreclosure. In Chapter 13, late payments and fees, such as arrears, can be caught up over the 3 to 5 year period. It is also possible to modify a mortgage in Chapter 13 to reduce your payment, interest rate, and or the balance owed. It is also possible to cancel a second mortgage or HOA lien if the house is worth less than what is owed on the first mortgage. If you owe significantly more on your vehicle than it's worth, it's possible to reduce the loan's balance to the vehicle's value and or reduce the interest rate. However, similar to Chapter 7, Chapter 13 cannot discharge certain debts. Those include home mortgages and certain other long-term obligations like vehicle loans if you wish to keep the property, alimony or child support payments including arrears, certain recent tax obligations, student loan debts, debts arising from the overpayment of certain government benefits, DUI personal injury or wrongful death judgments, or restitution ordered as part of a criminal sentence. Now, these are only the basics of bankruptcy, and there are a multitude of nuances that I will discuss in further videos. If you have any questions or would like to discuss your bankruptcy options, Holland Law Group has experienced attorneys waiting for your call. We offer free consultations and are here to assist you with your debt and provide relief and a fresh start so you can live the debt-free, stress-free life that you deserve.